In a big setback to the Aam Aadmi Party, the Delhi High Court dismissed Chief Minister Arvind Kejriwal's plea challenging his arrest by the ED in the alleged liquor policy scam. The Delhi High Court, in its scathing observation, said that the material collected by the probe agency reveals Arvind Kejriwal conspired and was actively involved in the use and concealment of proceeds of crime, not just as an individual but also as a convener of the Aam Aadmi Party. The court further stated that the ED was in possession of enough material which had led them to arrest Arvind Kejriwal. From questioning approvers' claim to linking electoral bonds to the case, the Delhi High Court rejected all claims made by the Delhi Chief Minister. The BJP slamming the AAP, saying that the ED investigation is revealing stunning facts. The Aam Aadmi Party, on the other hand, maintaining that political conspiracy, their charge of political conspiracy stands, and it's mulling a move to the Supreme Court ASAP. Is the AAP failing the credibility test? We'll have to wait and watch. Till when will the Delhi Sarkar run from jail? That's another question. Sardar R.P. Singh with us, Piyush Joshi, political analyst with us, and Dr. Ranganathan stays on. Sardar R.P. Singh, the arrest is valid. The conviction so far has not come forth. Because the arrest has been done on grounds that the ED claimed that it has used the right sections of the PMLA with the right charges. So that's where it is.
Well, Anand, let me just read out one para. Material created by ED, this is High Court's observation. Material created by ED reveals that Kejriwal conspired and was involved in formulation of excise policy, used proceed of crime. We just said all this, but let me tell you what is there in the ED's remand note. It categorically mentions about a bank account number. They say what is the proof? The bank account number is 10220210004647 in UCO Bank where money was transferred. This is on record of the ED remand note. And also, there are the evidences by individuals under section 164 in the court. And the gentleman name is Ashok Patel, Kiran Bhai Patel, Jagdish Sharma. And all of them have said they have routed some like 12 crore rupees, some 7.1 crore rupees, 16 crore rupees, some 7.5 crore rupees. These are evidences which who has said everything on record under section 164 in the court. So, court would have observed all this. That's why court has given what observation the court has given, and the court has given the decision according to that. But fact is, why they want to run away from this? I mean, everyone knows that Kejriwal is the kingpin of the complete thing, and then Vijay Nair and others was the people who were helping him out. Vijay Nair was allotted a bungalow next to Mr. Kejriwal's bungalow, and that was a minister's bungalow, sorry. And then the minister never used to stay in that bungalow, and that's why minister was called to ask, why did you give your bungalow to that man? He said no. He said that I was asked about this. Kailash Gowda has on record saying that yes, I was asked about that. How could Mr. Vijay Nair stay in his bungalow? Because it has an easy access, and to send a message that Vijay Nair is our man. So there are a lot of proofs on record.
Propriety and claims.
And so the court has put a stamp on that.
Propriety and claims, etc., do not affirm guilt. So there is a political aspect to it. There is a legal aspect to it. Piyush Joshi, the biggest thing is the arrest is validated. That means the arrest is legal. This is a dent. This is a dent to the AAP itself, because when it goes out to the communication कि केजरीवाल का arrest court ने सही ठहराया, legal हो गया. Should you have actually moved this aspect, this premise in the first place?
Well, certainly not. I'll be very frank with it. I don't know. I'm sure that they are having much wiser legal counsel than I am. I happen to be a physician. I'm not a lawyer. But still, I think that this order was expected, because the arrest could not be dubbed as illegal as such, because you have been summoned for 8 to 9 times, and then thereafter you have been arrested. So according to the draconian law, which I still maintain it is a draconian law nevertheless, but still under that particular law, and after the amendments, basically the arrest was definitely going to be dubbed as legal by the Honorable High Court, and they have rightly done so. But that doesn't stop from us questioning the Bharatiya Janata Party and the Enforcement Directorate. We have been hearing the same kinds of arguments, over and over by the BJP, that Vijay Nair resided there and all that. So this investigation has been on for 2 years. And 2 years you have not been able to get a single conviction, which is very much in record with the Enforcement Directorate, that it is able to get conviction only in 25 cases out of the thousands it has registered. So I think what is happening in this particular case, sir. RP Singh sir, I did not. You will get your turn. Just let me make my point.
सर
and
आप
then you can,
मिसकोट कर रहे हैं,
and
सर
then
आप
you can counter
मिसकोट
if
कर
I'm
रहे हैं।
wrong.
25 में से 24 को कन्विक्शन हुआ सर, 25 25 केसेस का फैसला आया और 24
ठीक
को
है, चलो मेरा
conviction हुआ,
नंबर
सर।
गलत था। मैं मुझे लग रहा था 25 में कन्विक्शन हुआ है, आपने मुझे करेक्ट कर दिया 25 में नहीं 24 में ही कन्विक्शन हुआ है, तो मैंने आपकी बात मान ली।
नहीं, पर इसमें
ठीक है?
एक और लेकिन
फैसला 25 में आया
सर मैं मान रहा हूँ फैसला 25 में आया, मैं वही बोल रहा था हजारों केस रजिस्टर किए एनफोर्समेंट डायरेक्टरेट में, उसमें से 25 में कन्विक्शन आया, मुझे तो आपने बोल दिया
इसमें
25 में नहीं आया, 24 में आया।
the
हाँ,
important
let's
aspect
go.
is that cases under PMLA.
court takes its own time
I have
and
limited
this is a
time.
white collar
I just
crime.
want to say
It takes
2-3
a lot
things.
of
1
time
minute.
to
No.
get things together,
No,
put things
it's
together, all this
convictions
together.
under PMLA have been received, or the ED has been able to enforce convictions under PMLA. That's one important aspect. Secondly, sir, the court itself was apprised of the fact that the investigations got delayed because summons were ignored over the last 5 to 6 months. So it also impeded investigation. That's another aspect. Thirdly, sir,
Okay, I agree with you, Anand ji.
thirdly, the court has said that the aspect of Mr. Kejriwal conspired privately and also as convenor of AAP, as a private individual and also convenor of AAP. It's very serious observation, sir, as it upholds the arrest or the legality of the arrest. Dr. Ranganathan, quick comment and then I'll come back to you, Piyush ji, and also Sardar RP Singh. Yes.
Now, it is still, I would say, Anand, a partial victory for Arvind Kejriwal and Piyush ji and all the AAP supporters, because while 94% of Arvind Kejriwal still remains in jail, 4.5 किलो की जो कॉन्शियस थी ना वो एस्केप हो गई है उनकी। पीयूष जी फिर हंस रहे हैं। So 6% of Kejriwal is out of jail. That is 4.5 kilos of his conscience. Piyush ji talked about, well, it was nobody's grouse that the arrest would not be made illegal. What he conveniently does not say is the following. I would like him to comment on this, that the High Court had said, and I am quoting now, the ED documents reveal, this is the High Court saying, ED documents reveal Kejriwal actively conspired and was involved in concealing proceeds of crime. Now I want to ask Piyush ji, if the matter was simply about illegality or legality of this arrest, why did the High Court make this observation, and what is your view about this observation, Piyush ji?
Absolutely, perfectly right. Now, all I'm saying, Anand ji, on this matter as such, is that if the matter is so clear, if the ED's evidences are so clear, then I think the Honorable High Court might have gone ahead and adjudicated on the matter. And with a finality
sir, all of us can't do that, because here the premise was, is the arrest illegal? Here the premise was, is the arrest illegal?
Anand ji, I agree that the premise was that the arrest is illegal, and that was the application before the Honorable High Court, and the Honorable High Court said that prima facie it looks like that. So prima facie is not finality, right? It is a prima facie evidence, and it can very well be proven in the later.
The High Court could have said that the ED has used the right sections to arrest the person, and the arrest is legal. It need not have said that there is clearly conspiracy, the charge of receiving proceeds of crime, the charge of it being done in a company that makes Aam Aadmi Party, the entire party a party to this crime and to beneficiary of the proceeds of the crime. These are serious observations.
It is for the Honorable Justice to decide what he wants and what is not, and what he does not want to speak in his observation. It is his right. But it is also my right to have a difference of opinion. Though I am bound to accept
absolutely. Will the matter be heard in Supreme Court? Is there going to be an urgent hearing? What is the court going to say on that? We'll keep close tabs. Gentlemen, I've run out of time. We will take this up. We'll take this up in detail, sir. I'm way over time. I have to wind up. Thank you very, very much. Stay with us. Brass Tacks with Zaka Jacob after the break.